So these past couple of years as an executive coach have been eye-opening for me, seeing not just how corporations behave badly, but immorally and illegally, which is obviously against their own best interests, not to mention yours. But despite this fact, corporations continue to do it. So understanding your rights and how to protect yourself is absolutely crucial. Today, I am sharing some of the top mistakes I've seen both employees and clients make and what you should do instead. If you're new to my channel, hi, I'm Kristen. I'm a former hiring manager, attorney, and tech exec turned executive career coach. I help mid to senior level corporate women get promoted and transition into work they love. And if you are interested in that, or you're interested in curating a kind, supportive community that wants to uplift others and navigate corporate America, I would love for you to like, share, and subscribe. So it's unfortunate that this still happens and that I have to say it, but you never, ever, ever tell them you are pregnant before you start the job. So let me first say I have had multiple clients push back on me with this, and you might be screaming at me in your head right now. They feel like it would be dishonest. They feel like they would be getting off on the wrong foot with their new employer. But I have seen too many times offers rescinded once someone found out they were pregnant. And yes, this is despite the fact that pregnancy discrimination has been illegal since 1978. And the thing about sharing this information before you actually have the job, and I do mean butts in seats, is the fact that it is so much harder to prove. Take, for example, this woman named Sarah. Her story went viral on LinkedIn just last year. Just a few months ago, Sarah had a new offer for a new job. She was really excited about it. She had a letter, they had set a start date, and she even knew what her pipeline and target were for the upcoming quarter. The recruiter called her to ask her if she had any last-minute questions, and they agreed to hop on the call. And Sarah asked about maternity benefits. She didn't share that she was pregnant. She asked about maternity benefits. And within days, she received an email from the same recruiter saying that her offer had been rescinded. Yep, today. Not 20 years ago. You know, it's interesting that companies are still so short-sighted about pregnancy because not only are we not provided maternity leave, of course, in the United States, but the average leave for companies that do provide it, it's less than 6 months, where the average tenure of an employee is 4 to 5 years. And what I think about is how much Sarah could have accomplished if she was provided the opportunity. So while you might feel as though you're being immoral or dishonest or displeasing even with a new boss, it's so important to protect yourself, especially if you need the income and I imagine the healthcare as well. And just a footnote to this, while Sarah did have a very strong case, she chose not to pursue litigation. And I know you know this, but discrimination does not end in pregnancy. Mothers make on average $11,000 less than other women who are already making an average of 79 to 80 cents on the dollar, depending on race. And they're 79% less likely to be hired than other women. So again, protect yourself, and a good employer will understand why. Number 2, and I know this can be controversial, but save any evidence of wrongdoing to an outside source. So I know that this can be a little bit confusing and may even stoke some anxiety because when I say save any company data to a personal source, you might immediately think, oh my God, that would constitute a data breach and I could be getting in a lot more trouble than I'm already in. Now, obviously, I do not want you to make any bad situation worse. So let's go through the why and let's go through the how. So first and foremost, you're not wrong. I know a lot of companies have policies to protect their data and their IP, and they don't want you to take the data and save it to any outside source. So what I'm talking about is obviously evidence of wrongdoing that you would need to go to HR with regard to a bully or a boss that was behaving badly or any type of immoral or illegal behavior. So the first thing you want to do in saving this information is make sure that you understand the policy with regard to how long your company keeps emails, Slack messages, etc. I know for my last organization, it was 6 months, and if you wanted to keep any emails longer than that, you needed to put it in a separate folder. But believe me when I say that alone is not enough. Years ago, I had a client in academia that knew she was going to have a very difficult time being tenured. There hadn't been a woman tenured in her department for 30 years, and she knew that those in charge would do whatever they could to make sure that she looked like her credentials were lacking. And boy, was she right. Not only was the folder in her email where she kept this evidence deleted, but the one on her laptop was as well. But luckily, she had saved everything to a Dropbox, and everything had a date and timestamp. Now, depending on your personal situation and your company policy, you might not want to save it to your personal email or a Dropbox, but I absolutely recommend saving it to a folder on your email and saving it on your desktop as well. And here is the backup. If you feel as though you would trigger a data breach and you would get yourself in a lot of trouble by sending this to a personal email or to a Dropbox, then I want you to use your phone and I want you to take screenshots of the information. It is so imperative that you have this. As a former litigator, I cannot tell you how many times I have seen this type of information disappear when push comes to shove. I hope that there is never a situation where you are here and you need to make these decisions, but I have absolutely seen this save clients, especially when it comes to potential litigation. And I think it's really important for you to protect yourself over the company because nobody else is going to do it. Number 3, do not assume that a company policy is legal. So years ago, I worked for a company doing sales and account management for a legal product, and you had to be a lawyer to be in said role. Suddenly and without warning, my boss sent out an email saying that our company policy regarding mileage had changed, and we would no longer be reimbursed for going anywhere outside of a client site. Now, this was problematic because oftentimes as a salesperson, we had to hold lunches, so we would go pick that up. We would go to Costco to find tchotchkes and candy and things such as that we would bring to client visits. And as it turned out, in the state of California where I lived, such a policy was illegal. Now, it's never a fun thing to go to your boss and say, hey, you can't do this, this violates the law. But I positioned it in a way saying, hey, I know that your region and your territory in which you manage is larger than California, but I do want to bring to your attention, and I sent her the statute. A few days later, all of the California reps received a note saying, hey, disregard this, you'll be reimbursed for all mileage. So if something sounds weird or fishy to you, don't hesitate to look it up. Remember, the company is always looking out for their best interest and not yours. And while their reasoning might not be malicious, again, you need to protect yourself because you're the only one who will. Number 4, do not assume that Glassdoor is right. And the same with Forbes and Fortune and anything else that is pay to play. So for years, I used to recommend Glassdoor to private clients. It would allow them to check out the company's culture and see what other employees had to say. And when I initially went back from coaching to my last corporate job, I had the honor of leading the Women's Resource Group. And as it turns out, we had a paid relationship with Glassdoor, which many larger companies do. And with this paid partnership, certain employees were encouraged to write reviews on Glassdoor that then went to the top of the list because they were favorable. And any reviews that were negative or bad were filtered and not seen when you initially went to this website. Now, while at the time I worked for what I considered a really good company, this policy did not sit well with me. And what I did to test it is I went and reviewed another corporation I had worked for where they laid people off systematically every 2 years. And despite the fact that I knew that company did not have a safe or employee-forward culture, the reviews were still very positive. So I did a little research and I found out that Glassdoor had a proprietary algorithm which allowed them to sort information. And with this pay-to-play system, that meant that the companies that paid had better reputations than the companies that did not. In fact, I went to look for my negative review a few days after leaving it, and I could not find it anywhere. So with any organization or publication where it is paid to play, be very discerning about the information you are reading. Just make sure you take everything with a grain of salt and look at other websites. Number 5, discuss your salary. I've said this before in other videos. If your company has a policy where you are not allowed to discuss your salary because it is confidential, they have an illegal policy which violates federal law. The National Labor Relations Act, which was passed in the 1930s, prohibits companies from telling employees that they cannot discuss salary. And while, yes, I guess this could fall under the category of do not assume that a company's policy is legal, I thought this deserved its own call out. Because I've noticed with a lot of clients that even if it is not overt, it's definitely implied that salary is confidential. But by not discussing our salary, we don't understand when we might be discriminated against. We might not be earning what we are worth, and this is going to impact our families and our retirement. Now, at the same time, I want to give you a tip to use if you happen to live in a state where they can ask about previous salary. I know a lot of states have changed this policy and it is illegal, but if you are still subject to that, you know that it disproportionately impacts women. So let's use the confidentiality clause to your advantage. And I want you to say something like this if you're asked about previous salary. You would say something such as, While I can't share that information because it would violate my current company's confidentiality policy, I can tell you that I'm looking at roles between X and Y. And obviously, you're going to do the research about the salary ahead of time. And I think discussing salary is so important that I made a video about that, so I'm going to link that in the notes below. Let me know in the comments below, is there anything that I've left off the list that you would want to include as far as protecting yourself at work? And again, if you like this video, please like, share, and subscribe so we can curate a community where we uplift one another. I come out with new videos each week, and until then, take care.